Hi, this is Alan Gassman, and I am here to introduce to you Colleen Flynn. Colleen is a wonderful person and a wonderful employment lawyer, and we're going to talk about the new Florida COVID-19, what I call the non-vaxxer right to work law. But first, Colleen, just before we started here, you were telling me about some OSHA laws and some CMS laws, and I'm sure that some people on this webinar would like to know at least what they are so they can get their antenna up. What's going on?
Well, as I'm sure a lot of people have heard, OSHA passed regulations that will apply to employers that have 100 or more employees, and it is the regulation that would require employers that they either mandate the vaccine or weekly testing. So an employer wouldn't have to mandate the vaccine, they would just have to implement weekly testing. As of right now, the OSHA rule is stayed by the courts pending litigation. So right now, no one has to comply with the OSHA 100 employer rule. And likewise, there is a rule by CMS for CMS certified facilities. So not just if you are an office that takes Medicare or Medicaid, you have to actually be certified. So like a surgery center, something like that. So if you're certified by Medicare or Medicaid and you're subject to the Medicare or Medicaid COPs, you would have to abide by the CMS regulation. It's the CMS ETS, Emergency Technical Standard, and that required vaccination for employees who are covered by that. You were able to give religious or medical exemptions only, and only under special, very specific rules, not just if somebody says, hey, I have a medical condition. There was a rule that required a detailed medical statement. That too, as of last week, has been stayed nationwide. So if you are a CMS certified facility, watch that, because we don't know when that will be lifted or what's going to happen with that. I believe as of right now, Alan and I may have another seminar upcoming, and that will be the topic between the OSHA, the CMS, and then we have our Florida law, which provides exemptions. Alan has created a very catchy title for it. I think the Florida legislature would disagree with the title, but we'll go with Alan's for today.
People disagree with me all the time. Okay, if you're a lawyer or a CPA and you would like free continuing education credit for this presentation, tough luck. You're not getting it. We didn't have time to register it. How to ask a question. Besides emailing us, and you'll see our email address at the bottom of each slide, you can go ahead and click on the question, the red arrow, that will open up your question panel, or click on the question triangle there, and then you can type in the question, and then we'll pretend to know the answer. All right, and then we have, we have an upcoming one. I didn't realize it. Okay, Monday, December 13th, 1 p.m., the OSHA and the CMS laws. I'm looking forward to learning all about that. Okay, so Colleen, here is our first slide. What is this?
Okay. So a few weeks ago, our legislature in Florida passed a law pertaining to COVID-19 vaccinations for private employers. So the law is clear that no government or public school or public government entity can require the COVID-19 vaccination. For private employers, which is what we're going to be speaking about today, there was a statute passed, and that statute says that while a private employer can still have a COVID-19 mandatory vaccination policy, they have to give 5 exemptions to employees who qualify. What is currently up on the screen right now is the emergency rule, and the emergency rule was referred to in the statute. So the statute's passed, and then the emergency rule gives the standards for the exemptions arising out of the statute. And so there were some terms in the statute that weren't defined, such as anticipated pregnancy, something that's not a legal term. And so the emergency rule defines some of these things that you'll see that the legislature passed. Also with the emergency rule, the Department of Health promulgated forms that that employers need to use if an employee wants to claim an exemption, and they're in the PowerPoint, and we'll get to those as well next. So if we start the first slide, we'll talk about what are the exemptions that you have to grant under Florida law. So what happened was after, this summer we heard about the bill that passed that prohibited a business from requiring proof of COVID-19 vaccination from its clients or customers. At that point in time, there was nothing in the laws that had passed last session regarding private employers and their employees. It only pertained to clients and customers. So you couldn't mandate that a client or customer show you proof of COVID-19 vaccination if you're a private business. You could require them to wear masks, that's no problem. You can still require your customers to wear masks, but you couldn't require that they show you their COVID-19 card to get access to your business. I've been in New York recently in the past couple of months. You can't get in a restaurant without showing your vaccine card. You can't go to Broadway without showing your vaccine card. So it's a very different world from Florida and some of the northeastern states. But what the new law targets is they say you can still have a COVID-19 mandatory vaccination policy for your employees. However, you have to give 5 exemptions. So this goes beyond what I'm sure most of you heard us talking about the past year, basically since the vaccine came out, that you could mandate the vaccine, but that you had to grant an exemption for either a medical reason or a sincerely held religious belief. And those are under federal law. That's under the ADA as well as Title VII for the religious exemption. And so under the Title VII religious exemption, you are permitted to ask employees about their sincerely held religious belief. But under this Florida law, we start with the medical. So if you want to go back one slide, Alan, we'll talk about the medical exemption under Florida law. So now the first exemption that employers must grant under Florida law is a medical exemption. And that says that an employer must grant an exemption if an employee presents a statement signed by a physician, physician assistant, or advanced registered nurse, which states that in their opinion, COVID vaccination is not in the best medical interest of the employee. So it doesn't ask what is the disability. It doesn't ask what the medical condition is. It just asks that the medical provider certify that in their opinion, that the COVID-19 is not in the person's best interest, a medical interest. And under this exemption, it also states that exemptions must be made for pregnancy or anticipated pregnancy. Now, those of you who have asked me questions in the past will know that generally pregnancy in and of itself is not a disability. Pregnancy falls under the Pregnancy Discrimination Act, not under the Americans with Disabilities Act, because a healthy pregnancy is not a disability. You could have a disability while you are pregnant if you have some kind of gestational difficulties or preeclampsia, or there's certain things that could make you disabled while you're pregnant, but generally we don't view pregnancy in and of itself as a disability. But under the Florida law that talks about a medical exemption as opposed to a disability related exemption, it also allows people to claim exemption for pregnancy or anticipated pregnancy. And that was one of those terms that were defined in the emergency rule that was up on the prior slide that we just looked at. And you'll see later, after we get through these 5 exemptions, the forms that the Department of Health in Florida has promulgated that must be used by employers in the case that a person wants an exemption. Now, the employer must accept, and it's the employee's medical person's representation that is in the best interest of the person. But the employer must also accept the employee's representation that they are going to have an anticipated pregnancy. It doesn't mean that you get a medical certification from their doctor that they're possibly going to be pregnant, but it's their statement. It's the employee's statement. So if somebody has a medical condition, let's say a male who can't be pregnant, who wants to claim that they have a medical condition that their doctor has said they shouldn't be vaccinated, then that's fine. They give the medical form to the doctor fills it out, they give it to you. If they don't have their doctor, registered nurse or PA fill it out, then you don't have to accept that medical exemption, let's say from a man. Now, if it was a woman who filled out the form and said it was their intent to become pregnant, you have to accept that. Now, of course, as an employment lawyer, myself and my associate like to think of all sorts of crazy scenarios, but what if somebody who is clearly above childbearing years says, it's my intent to become pregnant? And, let's say it's me, I'm 48 years old. I think it's unlikely that I am in childbearing years, but we are really not permitted under the Florida law to ask questions about that. Now, I do think if it was, somebody obviously who was male who signed that, or if it was a, 70-something-year-old female, I think that's a different scenario than if it's somebody possibly like me who is trying to sign that form. But it is one of those things that we have no answer on today, December, whatever the date is, 6th, since this law just went into effect. So now moving on to the next exemption, we can change the slide here, and we see the religious exemption. So under the Florida law, employers must grant an exemption for a sincerely held religious belief. And here's the interesting thing, employers are prohibited from inquiring into the veracity of the employee's religious beliefs. This is different than federal EEO law. So those of you who may have inquired a few months ago and we gave you answers under Title VII, this is different. You may not inquire into the veracity of the employee's religious beliefs or if they're sincerely held. If those of you out there, HR professionals who've been following, you've seen the forms asking about, have you had other vaccines? What are you against both vaccines? What is your sincerely held religious belief? What do you do that's contra to that sincerely held religious belief? That's all fine under Title VII. And that was all fine until this law was passed by our Florida legislature. It is now no longer fine. If a Florida employee signs this religious exemption form that you'll see at the end, you have to accept it, and you have to accept the veracity of their statement. Again, if you're in a different state, this is probably very different from what you're experiencing in your state, especially if you're in a northeastern state that doesn't have laws such as this. Okay, next exemption. COVID-19 immunity. This is another one. This is very interesting. So we talked earlier about the CMS and the OSHA rules that are out there that are currently stayed, but the CMS rule is very specific about, COVID-19 immunity forever and ever does not, get you out of being vaccinated under the CMS rule. It does, however, get you a delay for whatever the period of time is that it is contraindicated for somebody to be vaccinated after they've had COVID-19. So if your doctor says you need to wait 60 days after you've recovered from it to get the vaccine, then you'd be permitted to give that employee a delay under the CMS. Completely different. Under Florida law, there actually is a provision in the law that says an employee may claim an exemption from an employer's mandatory COVID-19 vaccine policy by presenting an exemption statement showing that the employee has immunity to COVID-19, documented by a valid laboratory test, which can be either a diagnostic or antibody test, which has received full approval or emergency use approval by the FDA. So you'll see the form in a little bit that someone can fill out, and you'll see what they need to provide to you to show that they've had COVID-19. We don't have any history with this exemption. This is, to my knowledge, I don't know other states who have used this. I don't know what an employer could do if they got a test back and it showed a number of antibodies and what the actual number is for immunity, because that's not set forth in the statute. So if somebody is claiming this, they'll have to present you with a COVID-19 immunity test, an antibodies test showing that they've recovered from it and what that status is. Now, of course, we could discuss all day, how long is that going to last? How long do those antibodies last? All these things are just unprecedented. We don't know. This law literally just went into effect. And so we are all navigating it together at this point. Okay, the next fourth category is that if an employee agrees to comply with regular testing by presenting an exemption statement, the testing must be provided at no cost to the employee. An employer may test the employee no more than weekly or upon evidence of COVID-19 symptoms using a diagnostic test that has received approval from the FDA. The statute is silent on whether at-home tests work, or work to satisfy this law, but the at-home test that is approved by the FDA would likely meet the testing requirement. But what I will say to you is that you don't have to accept the at-home test. You don't have to use the at-home test. I think there's several issues with the at-home test. One is if you are, let's say, the HR professional or the operations person, and you want to say, okay, you can come to my office and do the at-home test here. We will have tests here, You will swab yourself in front of me. I will wait for the results and tell you what it is. I think that's perfectly fine. I think the problems arise, and I don't think you should do this, is if somebody says, I'm going to test myself at home and I'll tell you the result. How do you know, A, they're swabbing themselves, and B, how do you know that they're showing you the test results? The issue, though, is that the testing must be at no cost to the employee. And therefore, if you want the employee to go get a test at, Walgreens and CVS, to the extent that they may become a cost after a while. Right now, we know they're free, but some places do charge. Private pharmacies that aren't part of this program, the federal program, do charge. The employer has to pay the cost of that. And while the statute is silent on hours or paying for hours worked, the statute does say it has to be provided at no cost to the employee. So to me, not only must the test be free, but it's no cost, because otherwise they're losing money if they have to do it on their own time. So in an abundance of caution at this moment, I would tell you not only should you let the person go on work time, but that you have to pay for it if you want to send them somewhere else to have the test done. Okay, next slide.
Colleen, before we move to the next slide, if they are using the religion exemption or they already had an exemption or the health exemption, can you still require weekly testing?
I think you can. It doesn't say that you cannot. This is all new territory. We're all, requiring it. Now, the only thing I will say is that, if you want to require weekly testing, you just have to pay for it yourself. And you can't do more than once a week.
I could require weekly testing of any and all employees who fit under any of these exceptions, probably.
At this moment, we don't have anything to the contrary. It doesn't say that if you have a religious exemption, you can't be tested. But, it also says that, you have to give somebody an exemption who agrees to comply with regular testing. So, it may be a multi-reason exemption for somebody.
Now, what about one of the questions we have is, what about new hires? Can I refuse to hire someone because they're going to fit under one of these exemptions, or I have to hire people as long as they're willing to do the weekly testing?
Correct, as long as they'll agree to the, weekly testing. The Florida forms are pretty clear that, that if an employer has a mandatory vaccine, they have to allow these 5 exemptions. You can't just say, I'm grandfathering everybody in and nobody new is going to fall under that. This is a law in Florida, and there are penalties for not complying with it.
Okay. Now, if I hire them, am I allowed to put them somewhere safe and away from where they would have client contact and contact with other employees? Am I allowed to put them in solitary confinement?
I don't know. I mean, that's something that, if you look at the statute, we can't take remedial or negative action against employees who have an exemption. And so to some certain extent, if this is preventing them from doing their job, or we're now saying you can't be in this job because you're not vaccinated, that would run afoul of the statute, in my opinion, at this moment from what we've seen. I mean, we haven't seen any enforcement of it because it's obviously just going into effect. So we want to be cautious, but no, this would apply also to new hires.
Okay. Next exception.
The next slide is that if an employee agrees to comply with an employer's reasonable written requirements to use PPE in the presence of other employees or persons, so that could be clients, then the PPE must be provided by the employer. The statute does not define PPE or differentiate between cloth, face coverings, and face masks. So, again, if somebody is saying, listen, I don't want to be I do not want to be vaccinated, and I will agree to use, personal protective equipment. But again, it doesn't talk about exactly what this PPE is. And just remember, private employers can always have a policy that require face masks. I mean, we still have one in my firm when you are leaving your office and are in the presence of other people, that you need to wear your mask. And quite honestly, you can always take disciplinary action against employees who are not following the rules. Or if you say, we only let 2 people in the conference room, you're only wearing your mask, you're sitting at certain ends of the table, and somebody continuously is not following that rule, then that's grounds for disciplinary action. regardless of whether you even have a mandatory vaccine policy. So for putting aside this statute, you can have rules, you can have rules that say you must wear your mask at work all day, every day. You must, you must, stay socially distanced from other individuals. And if somebody's not following those rules, then you can always discipline them. You can ask people for their, if they're vaccinated or not, even if you don't have a mandatory vaccine policy. And that's helpful for a variety of reasons. That's helpful because you'll need to know if somebody has a work exposure, whether or not they have to quarantine. Because don't forget, the CDC rules currently say that if you're vaccinated and you're exposed to somebody, you don't have to quarantine. But if you're unvaccinated and you're exposed to somebody, then you do have to quarantine. So there are reasons that you need to know whether your employees are or are not vaccinated. And none of that would be a violation of the statute at this point in time. So if we move to the next, go ahead.
You can discriminate and say only the people who have not been vaccinated must wear the PPE in the office.
If you don't have, yes, I mean, the reality is you can have a rule that says non-vaccinated people must wear, whatever face coverings, whatever you want to say, and that people who are vaccinated are not required to. That's fine. And, quite honestly, that was the rule or the recommendation of the CDC back, earlier in the spring before the Delta variant. But at this point, if you're following the CDC recommendations, it is that all people indoors wear face covering. So I probably right now would not have that rule, not because of discrimination, just because of the what's going on with.
Can you pay people who have been vaccinated more than you pay people who haven't been vaccinated?
Well, I wouldn't pay people like on a different pay scale because, that could be deemed, discrimination under this statute. But, I know lots of people who were giving out bonuses and whatnot to people once they provided their vaccine card. And so that was being done. And I don't necessarily see that that in and of itself would be a huge problem, but you'll see from our next slide, if you want to turn to the next slide.
Wanting to go to this next slide, Colleen.
Well, because this is on the next slide. Okay. Well, so there's another slide that's coming up, maybe it's on the next one, that has the penalties for violating this rule. And so when we get to that one, let's see, do we not have that in here? There we go. Okay, so let's skip ahead to this one. So since Alan's asking the questions. So if an employer improperly applies or denies an exemption, which results in the employee being terminated or constructively terminated, they can get a fine. Okay, so to your question about can I make them work somewhere else or work in a different job, to me that's a problem if it results in somewhat of what somebody could say was a constructive termination, meaning I can't do my job anymore, or you're basically telling me I have to go, do something that I don't do because you don't want me out in the front. And I think that would be a violation if they're no longer doing their job. And so right now we have a $10,000 fine per violation. If you have fewer than 100 employees, and it's a $50,000 fine per violation if you have 100 or more employees. So you can't deny an exemption or terminate somebody or, constructively terminate them. So, think about that. This is all new territory and we're all trying to be very cautious, but we're all trying to also be conscious of people's health. And it is a little difficult to navigate sometimes this new statute if you're just trying to be ultra conscious. So that's what I'll say on that, because we just don't know where the enforcement is going to go by the state. So, you may want to be cautious. So those are the fines. So if we want to go back a couple of slides, since Alan was jumping ahead on the penalties. So, this is, just some commentary because it puts us in a bad situation sometimes, because we do have a duty under the OSHA General Duties Clause to provide a safe and healthy work environment. And when you read the recommendations from OSHA regarding a lot of things, it does pertain to PPE and physical distancing and air filtration and workspaces. So we do have all those things that we need to do as well to keep our employees safe. But this OSHA rule that is currently on hold with the courts was part of that overall OSHA strategy to try to, provide a safe work environment for employees. I think some of the questions people have are, is it a workers' comp claim? What's going to happen? I just don't know with that. I think right now it's so hard to say that, somebody got COVID at work. And, the best defense you can have about that is having policies in place that, require social distancing, require face masks. You can have the mandatory vaccine policy subject to these exceptions. And that should help protect you if you're showing that you're following all of these recommendations by, OSHA to keep employees safe.
Colleen, what do you see as the main liability exposure? I mean, if my law firm does not enforce this, if we know that somebody hasn't had the vaccine and they give it to somebody else who hasn't had the vaccine, and they aren't wearing their mask like they should, is there a lot of liability exposure, or is it nothing to worry about?
Well, I mean, obviously, people worry about workers' comp. It's difficult the way work-related disease is discussed under the Florida workers' comp statute. It has to be a disease that's, common in this line of work, and that there weren't precautions being taken. So the best thing I can say is to put safety measures in place, to make people wear masks and make them social distance and things like that, to prove that you are trying to have a safe environment. I think in Florida, because we have this law and, sentiment by our lawmakers that they don't want to impose vaccines, I do not necessarily think that there's going to be a push for liability on employers because of not requiring vaccines, since obviously this is Florida, the push is really the other way. So I still think, maintaining safety policies, requiring masks, requiring when your clients come in to wear masks, requiring your employees to wear masks, limiting contact in conference rooms, things like that is really the smartest thing right now to try to keep everybody safe and comply with our current law that just went into effect the other day, which this is so new, we just don't know exactly how this is going to be enforced, whether they have manpower to enforce it. But what I will say is that if somebody is terminated after they've filled out an exemption form, or if somebody, if somebody says, I have a sincerely held religious belief and here's my form, and you say, I don't buy that for a second, you're fired. I think now you're going to get a penalty by the state of Florida because the person's going to sue and seek enforcement of that. So if we look at, you'll see here, the next slides are the forms that the Department of Health have promulgated. And this first one is the medical exemption from the COVID-19 vaccination. So the top part, the employee fills out, and you'll see the top part, it also says, you please select yes if this is on the basis of pregnancy or anticipated pregnancy. So if it's a female who fills that out, then you're done. That's all you need on that one. If it's if it's a medical reason, then the bottom part needs to be filled out by the medical provider. And so it says this, you'll see down at the bottom, this completed exemption statement requires the employer to allow the employee to opt out of the employee's COVID-19 vaccination requirements. And so you'll see right in the middle that talks about the physician, the PA, or the APRN statement, basically just says it is my professional opinion that basically that the COVID-19 vaccination is not in the best medical interest of the employee. So, vague, we don't know why, but once somebody signs that, who is a physician, PA, or nurse practitioner, and they sign that, that's the end of it. You have to give them an exemption.
Thus putting the medical practitioner at liability.
Yeah.
Turns out the person dies of COVID, and why did you say that? Well, she had watched a lot of Fox News and just felt that it would upset her a lot to get vaccinated, so I recommended against it. Okay, that's going to open the doctor up to a lot of liability.
So I think honestly that's the balancing act. Now you're asking a physician to really look at somebody's medical condition and not just look at their fear based on internet research or a story that somebody told them. You're really asking the doctor to look at the individual's medical condition and whether or not it might be contraindicated for that person. Because there are some people who do have legitimate medical reasons that they could not get the vaccine. We've all heard stories of people asking doctors to just give them a note that says that they can't get the vaccine. And most of the physicians that I've heard from have said, I don't give those notes. If somebody does have a legitimate reason, I'm happy to, fill out the form accordingly, but I, believe in it and I've had it, et cetera, et cetera. So the next one is our religious exemption form. And so you'll see right there that the employee just has to fill out where it says, I hereby declare I decline the vaccination because of a sincerely held religious belief. Now this is interesting, which may include a sincerely held moral or ethical belief. That's a little different than the Title VII law, which talks only about sincerely held religious beliefs. Now, to any of you who are out there who may have attended the seminar that I gave in person a few weeks ago, we talked a lot about sincerely held religious beliefs, and they can be non-mainstream. They can be religions you may not have heard about. They could be personal religions. They can be all sorts of things, but they all do talk about a sincerely held religious belief. So, it's not just, Catholic, Lutheran, Judaism. I mean, it is not just religions that we have all, that I would, say are mainstream or that we've all heard from. It can be a variety of things. This can be a sincerely held moral or ethical belief. And more importantly, the statute is clear that an employer shall not inquire into the veracity of the employee's religious beliefs, and that a completed exemption, that's the end of it. Now, you'll know if you attended some of the other things under Title VII, we do have the ability to ask some questions about people's sincerely held religious beliefs. I mean, we can't discount them just because we may disagree with them or we think they sound different from ours, but we do have some ability to make inquiry. This is not. Once they fill out this form and they give it to you, that's the end of that one. You have to accept it.
The form is misleading because it says a religious belief. So the religious belief may include
Right.
moral or ethical belief, but you could read, a layman could read this and say, well, I don't need a religious belief. I have a moral belief, or I have an ethical belief. So that's going to confuse a lot of people.
Well, not to get into, what do I think that means, but, we've heard a lot of talk about the ingredients in some of these vaccines that some people are, disagree using. And I think that's maybe what they're getting at there. I don't know. I was not up in Tallahassee when they passed this, but if they give you the statement, that's the end of the game. Okay, so this is the one that's very interesting to me. This is the exemption form from COVID-19 based on immunity. So this statement says that I declare, to the best of my knowledge, the laboratory documentation I am providing with this exemption statement is sufficient laboratory criteria for proof of COVID-19 immunity. And so then down below, you show the test, and then it says you attach a copy of the employee's test results to this form. So that's vague to me. It doesn't say, what number is the cutoff. So, I'm not quite even sure what to say on this one. It is extremely vague. It just says that, that they're providing proof that shows that they have some form of immunity, whether it's antibodies of some number. I don't know. And then the next form talks about exemption from COVID-19 vaccination based on the testing. And, this one says that I agreed to comply with regular periodic diagnostic testing for COVID-19 to occur not more than weekly, or if I have symptoms. So if somebody does have symptoms, you could test them more than weekly with a FDA emergency use authorized test at no cost to me. And again, I read at no cost to me. Obviously, that means that I cannot be charged for the test, but at absolutely no cost, does that mean that, I get to do it on work time? I think that's the safest interpretation at this moment in time for those people who really are concerned about, the possible penalties under this statute. I think that at no cost would mean during work time, because otherwise there is a cost to you. You're losing work time. And then our next slide is the exemption on employer provided PPE. I hereby declare I agree to comply with the employer's reasonable written requirements to use employer provided PPE when in the presence of other employees or other persons. So there's the last one right there. And so to that extent, you can, again, no definition of what PPE is under the statute, of whether it's N95 masks or whatnot. So you could require the employees to wear N95 masks when in the presence of other people, employees, customers, etc. if they sign that. And then if they're not complying, that's a disciplinary issue. If they're refusing to wear the mask or somebody refuses to be tested, that would be dealt with in a disciplinary fashion. And I would tell you to make certain that you have a lot of documentation of that, because otherwise somebody is going to say, they denied me my exemption, they should be fined $10,000, I should get unemployment, I'm going to sue them, et cetera, et cetera. So, if you get into a situation where somebody signed this form and now they're, not using it, or you catch them constantly refusing to wear their mask, then that's a whole different scenario.
Okay. Colleen, is there an attorney fee provision in this law when the employment lawyer sues the employer?
That's a good question. I don't recall off the top of my head. I haven't looked at that this morning, but I don't recall. I think the big thing was the penalties under the statute per employee, which is what everybody is focusing on.
Yeah. Okay. So can I tell you some of the questions we received?
Sure.
Okay. The law is only for employees, not independent contractors?
Correct. This
Okay.
law, well, wait a minute. Let me back this up. The Florida law, let me pull up what it says here, because it's clear under some of the other laws that they apply to it could be applied to interns, it could apply to contractors. Our Florida law, let's see what it says here. I believe we cannot allow anybody, let's see. Okay. Let's see. Full-time, part-time, or contract employee is how the law says. So that's what it says right now. It says any full-time, part-time, or contract employee without providing the exemptions. Now, keep in mind too, that we also have the law that says that if it's a customer, you cannot ask for it. So, contract employee, do they mean contractors? Do they mean a true contract employee that you have a term, you're only here in June? I don't know how they're going to enforce that. So we really, really need to watch out. I'm not certain that I would mandate an independent contractor have the vaccine based on the fact that this does say contract employee. I think I would, make them fill out an exemption form or do something like that.
Okay, so then Rhonda says the fines appear to apply to those you've hired, but not necessarily those you refuse to hire.
That is a good point, because it does state, and I'm pulling up the statute right now.
You learn a lot when you give a presentation.
Yeah, these are really good questions, because these are very practical questions, and that we just don't know right now the way that it's going to be interpreted, because we don't have any case law or any guidance from the legislature, other than the fact that you cannot terminate someone for not complying with the statute here at this point. And so, to me, I think that, I would be cautious about refusing to hire. I would be, okay, so let's see here. A private employer may not impose the vaccination mandate for any full-time, part-time, or contract employee without providing the exceptions. So then it goes down at the bottom and states that if an employer who fails to comply with this section and terminates an employee, the termination includes the functional equivalent of the termination. The terminated employee may file a complaint with the Department of Legal Affairs alleging that an exemption has not been offered or has been improperly applied or denied, resulting in the employee's termination. And it says that the Department of Legal Affairs will conduct an investigation, and they must determine whether the employer has imposed a vaccine mandate, whether the employee submitted the proper exemption, complied with the specified condition, and whether the employee was terminated as a result. And so then it says if the Attorney General finds that an employee has been improperly terminated, then they impose the fine. And then it says, though, however, the Attorney General may not impose the fine on an employer that reinstates prior to the issuance a terminated employee with back pay to the date that the complaint was received. And so, you know, there is just nothing in here. It talks about if an employer fails to comply with these sections and terminates the employee, the terminated employee may be eligible for unemployment, okay? And then it says if the employee is terminated for refusing to comply with the vaccination mandate and the employer did not offer and properly apply the exemptions, it's not misconduct. So they will be definitely getting unemployment. And as most of us know, it gets charged to our tax basis. And so you're right. Rhonda, you are right about that. It talks about a terminated employee, that it does not talk about refusing to hire. But it does say, you know, an employer may not impose a policy that prohibits an employee from choosing to receive a COVID-19 vaccination. So, you know, even though it's poorly worded, I would still think that somebody may say, you know, you're refusing to hire me and refusing to let me have the exemptions would be the functional equivalent of it. I just don't know how that's going to be interpreted. I can see it both ways.
Colleen, well, thank you so much for a wonderful presentation. I reviewed the other questions. I think you've answered all the other questions as we went along. Please remember to join us Monday, December 13th, 1 p.m. on OSHA CMS, and I'm sure we'll be given a little bit of a commentary on what more we know about the new law we talked about today.
Right. Absolutely. Absolutely. So as these things go into effect, we'll keep watching and we'll see what the Department of Health says and what's coming out of Tallahassee.
Right. And then you've got our email addresses here. Please send Colleen the hard questions, me the easy questions. No one will get hurt. Have a great, great rest of your day.
Great. Thank you.
Thank you, Colleen. Really appreciate it. Take care.